Can you get crucial evidence during arbitration's limited discovery? Imagine trying to solve a puzzle with only some of the pieces. That's what gathering evidence in arbitration can feel like because of its limited discovery process. Arbitration is a popular choice for resolving business disputes because it's faster and less expensive than going to court. But unlike court cases, arbitration has rules that restrict how much evidence you can collect. In arbitration, discovery is meant to be simple and focused. It usually involves exchanging relevant documents and maybe taking a few depositions. The goal is to get enough evidence to make your case without wasting time or money. But this means you might not be able to access all the information you want, especially if it's not directly related to the case. The limits are intentional. Arbitration aims to resolve disputes quickly and cheaply. So, the rules restrict the scope of discovery. For example, you might only be allowed a certain number of depositions or a specific amount of document production. These restrictions can make it harder to gather every piece of evidence you think is important. From a business law perspective, understanding these limits is key. Companies should carefully review their arbitration clauses. Some clauses specify how much discovery is allowed, like limiting depositions to 1 or 2 people or restricting document requests to a certain number. Knowing this helps you plan your case better. To manage limited discovery effectively, focus on the most important evidence. Clearly define what you need to prove your case. Use strict deadlines for submitting requests and responses. Work closely with the arbitrator to make sure the discovery process stays fair and efficient. Even with these restrictions, arbitration can still be a good way to resolve disputes. It's faster and less costly than traditional litigation. By understanding what evidence you can get and how to get it within the rules, you can build a strong case. Remember, the key is to be strategic and focused in your evidence gathering. That way, you'll be ready to present your strongest arguments within the limits of arbitration's discovery process.